It's going to be gone. Worst case scenario is potential conflict. Probably is out. Maybe she should. I'm not there. The guy's not going to lie. She'll catch you if he does. It goes.
Theory goes beyond
We ready to start?
Yeah.
Yeah, whatever there.
You don't have to say anything.
Well,
I guess it'll be hard to why they were suggesting.
Starting the next semester, you don't even have to do that. I can just say early next semester, you're going to take one of these cases that you got. 2 months ago, then they'll do their witness interviews and go to the scene and have all the legal set.
You ready to go? Okay, what we're going to do is today we're not going to do short demonstrations of a one-hour examination in a criminal case. You guys are the panel. Mine is going to be very short because I have to do some of those at 5. So we are ready to go. The judge has called the case. State defense have announced ready, and he says, Mr. Ellison, you may proceed. Good morning, ladies and gentlemen. Good afternoon. So, my name is Bill Allison. I work for the elected county attorney at Travis County, Kenneth Oden. This is a criminal case that has been brought by the county attorney against Ms. Smythe. She is charged with an offense, and let me read to you what she is charged with. That on or about the 2nd day of January in the year 2000, Sandra Ann Smythe did intentionally and knowingly take and retain a child younger than 18 years of age, namely Julie Jones, knowing that taking or retaining the child violated the express terms of a judgment or order of a court disposing of the child's custody to wit, an order of the 126th Judicial District Court for Travis County, Texas, cause number 123456, style Sandra Ann Jones versus Anton Jones, which awards unsupervised visitation rights with the child Julie Jones to Anton Jones each and every Wednesday from 5 o'clock p.m. until 8:30 a.m. the next morning, and on alternate weekends beginning the second weekend of the year 2000 from Friday 5 o'clock p.m. to Sunday, 6 o'clock p.m. against the peace and dignity of the state of Texas. That is what we, the prosecutors, and the county attorney's office, and your elected county attorney Canada has charged the defendant with. That is a violation of the law. Now, is there anybody here who feels that having heard the allegations that have been filed against Ms. Smythe cannot follow or would not be able to sit fairly and listen to evidence in this type of case? I take it by your silence.
I don't understand all that stuff you just said.
I could read it to you again, but let me just tell you that at the end of the trial, after the evidence in the case is through, that at the end of the trial, the judge will give you what's called a charge, which is written, typewritten like this, and it will have the language that I just read to you on, and you'll be able to take that back in the jury room and look at it very carefully. So I realize this is early in the process, and it does have a lot of legal mumbo jumbo in it, but I think when you get to look at it from what the judge gives you at the end of the trial, you'll be able to understand it very clearly. Does anybody else have a problem? You can't take it by your silence, but everybody can follow along and sit in judgment and take some things. Let me, this, as I said, this is a criminal case, and there are certain rights that criminal defendants have in criminal trials. And I want to go over those with you so that you understand some of the rights that defendants have. For instance, defendants in criminal cases have the right to issue subpoenas to get witnesses to come to court to testify on their behalf. And the subpoena is a court order. They just apply for it, and the person ends up getting a piece of paper duly served by some law enforcement official, and they are then under the order of the court to come down here and give their testimony. And Ms. Smythe, the defendant in this case, has the right to issue subpoenas to have people come down here to testify. Is everybody okay with that? Okay. By your silence, everybody's okay with that. She has a right to have a jury decide her fate. That is, she could also make a decision that we would have to agree with, that she could just have a judge decide the facts of the case, but she has a right to have a jury decide it, and obviously we're here with a jury. She has exercised her right at a jury trial. Does anybody have a problem with the people who are charged with crimes exercising their right to have jury trials? I don't see any hands, so I suppose anybody has any problems with that. She has the right to be represented by a lawyer, and if she can't afford a lawyer, she can have one appointed for her. She has her own lawyer here, Mr. Shepherd, a very fine lawyer, and on her behalf, he will have the right and the opportunity to ask questions of anybody that the state puts on the stand. It's called cross-examination. So when I call a witness to the stand, and I'll get to ask them questions first, then the defendant's lawyer, Mr. Shepherd, will have the right to do what's called cross-examination. That's her right. So everybody understands that she has the right to cross-examine witnesses. Now this is a very important one, because Ms. Smythe has the right to remain silent. And that means that she does not have to say anything at all in this trial She does not have to take the stand. I can't call her to take the stand. I can't make her take the stand. I wouldn't ask her to do that. She has the right to remain silent, and you as jurors, now listen to this, because this is really important. You as jurors cannot take anything from the fact that she would exercise her right to remain silent. Because if she chooses not to take the stand, you can't go back in the jury room and say, boy, I sure would like to have heard her story. Does that cause a problem? Yes, sir.
Yeah, I just think, if I was accused of something, I would want to get up and tell my story. And it seems like if I don't, then I'm just saying I did.
Well, I understand, but let me tell you how the court solved the very problem that you've got, because it comes up all the time, and there is a way to solve it. Remember my talking to this gentleman here about the charge that comes at the end. Okay. In that charge is not going to be, it will be more than just the language of what she's charged with. What the judge also does in that jury charge is tells you what the law is that applies to this case, and tells you how to apply it. It's a roadmap not only for what she's accused of doing, but it's a roadmap for how you as jurors are to conduct yourself, how you're to behave. And one of the things the judge will instruct you, and in order to be on this jury, you've got to raise your hand and swear that you'll follow the law, be a good juror, and you can't be on the jury if you can't follow the law. Now, one of the instructions will be that the defendant has a right to remain silent, and you can't take anything from it. The fact that you might want to, if you were charged, doesn't make any difference, because you're not on trial, she's on trial. And so you can't consider anything that she says. Is there a problem with anything that she doesn't say, if she doesn't take the stand? So you're going to have a problem with that.
I can do what the judge says.
Okay. That's all I'm asking.
The judge's rules.
That's all we're asking. You can follow the rules, you can be on the jury if you're selected to be on the jury. Anybody else?
Yeah, I got a problem with that. It's kind of like in those TV shows where someone says something, the judge tells you to disregard it. Are you really going to forget all that?
Well, you have to, because that's what the law says. And the way you do that, let me tell you how you do that. If you're on this jury and something comes up and the judge says, just like you hear on TV, I'm instructing the jury not to consider it, okay? And then the evidentiary portion of the trial is over. You go back in the jury room and we're talking back there, and somebody brings up that thing that you're not supposed to talk about. It's your job, your personal job to say we can't talk about it. Everybody else that's on the jury sort of has to act as a policeman to say we can't talk about it. No problem? Okay. All right. There's a burden of proof. This is a criminal case, so there's a burden of proof in this case. And the burden of proof is beyond a reasonable doubt. The state willingly accepts its burden of proof, and we'll be happy to meet that burden of proof in this trial. But understand that the burden of proof that we are accepting is that we must prove to you each and every element of the case against Ms. Smythe. We don't have to prove to you beyond a reasonable doubt other things other than just the elements of the case. And the elements of the case will be set out in the jury charge that you'll have so you'll be able to see what the elements of the case are. But, for instance, we don't have to prove to you beyond a reasonable doubt that on a certain day Ms. Smythe was wearing a red dress or a blue dress if that becomes an issue in the case. That's not something we have to prove beyond a reasonable doubt. So everybody understand it and agree to follow the law. We just have to prove beyond a reasonable doubt just the elements of the case. Okay, it's proved beyond a reasonable doubt. It's not beyond any doubt, and it's not beyond the shadow of a doubt. It's not proved to perfection. It's just proved beyond a reasonable doubt. So if you get back in the jury room and somebody says, well, prove beyond a shadow of a doubt, you know what to say. That's not what they have to do, except prove beyond a reasonable doubt. I can see that my time is just about up, so I'm going to sit down and let Mr. Shepphard answer some questions.
I'm going to step out of character for a second, because Bill's going to leave. And let me do that. Now, believe it or not, I have heard probably, this is a concern I've tried to do with maybe 100 jury trials. I've probably heard 80 of those trials. The state's voir dire was just like that, except it lasted 2 hours. I want you to take some Frank Ryan, now district judge, he's a better district judge than voir dire. But the aggravated sexual assault statute of a child, aggravated sexual assault of a child statute, is extraordinarily complex. I mean, it's like a wiring diagram of Starship Enterprise. And he had it blown up, and he started his voir dire, and we spent 45 minutes explaining this to the jury. And they're just, you know, the ones that weren't noticeably asleep were just, you know, going, let me. That is what, if we ever catch any of y'all, if I walk into a courtroom, 3 or 4 or 5 or 10 years from now, you guys that doing this in voir dire, I'm just going to walk right in front of the jury and kick you in the ass. Did that accomplish anything? No. Well, it did actually get just bored them up. Really, I mean, what did that accomplish? And yet, that is the typical voir dire that you will see in. And the defense attorneys are going to do the same thing. They'll talk about the reasonable doubt. And there's some reasons to do that and ways to do it, but it's sort of this kind of boring water crap, and it just doesn't do genuine.
Right. I feel good about having not a little bit more for that.
We always kind of do things to our stuff, and we thought, let's just show that what we're really bad ones like. And I'm sorry you had to do that. Okay. So Bill, and tell people in the conference, I know that I won't be there and understand. I'll talk to you later. Okay, we're going to move on, and Bill has just finished putting the jury to sleep. Now, the defense has a problem, and the problem is this. The jurors have come in, they've been ran right around like sheep through pens, and they come in, they sat through, in a felony case, it may be an hour and a half to 2 hours of just what you've seen there. Terribly boring stuff. And even if it's not boring stuff, they're doing it right. They're tired, and they're worn out. So the defense really has to come in and be more efficient, because the people are exhausted, and you just have so much more of their attention you can generally rely on, and then they're just going to be burned out. So instead of getting an hour and a half, I really think the defense needs to try to do it in half the time the state does. And the truth of the matter is, you can do it that quickly. One of the reasons you can do it that quickly is, theoretically, you're paying attention while they're doing their voir dire. If they've done a terrible voir dire, it doesn't help you much. If they've done a really good voir dire, then you have learned a tremendous amount. You already know who the jurors are, you know a lot of their names, you know their personalities, who the talkers are, who the talkers aren't. And so it's really, you're way ahead. Now, I'm going to be starting up here at a disadvantage because I don't have that. Y'all are kind of cold Hamilton. But we'll just jump into it, and we'll see how this goes. And let me tell you also that I prepared these state's voir dire meticulously. 5 minutes ago, I was told I was doing defense voir dire, so this is a little ways. Ladies and gentlemen, my name is D.Shepphard. I know you've been here a long time, and I'll try to be as efficient as I can about this. I was paying attention during the earlier questioning. I'm going to try not to repeat myself. But there are a few things we do need to talk about. And there are no right or wrong answers on what we're going to talk about. When I ask you a question, it's not a quiz, you're not being graded, but it's important for the court to know your feelings about certain fundamental issues here to make sure the court can make, and the judge can make an intelligent choice of who's going to be the jurors in this case. Now, we have an unusual institution in this country, a lot of countries don't have it, and it's called court system. And the court system is set up to help people resolve arguments or disputes where they can't agree upon something. Two neighbors argue about where the property line is between their property. In the old days, they would take out their guns and shoot it out, and the survivor drew the line where the line ended up. We decided a long time ago as a society that that's probably not a very efficient way of doing anything. It doesn't work in the long run. So we created this court system. And just like we are right here today, there's a major disagreement that the courts are going to have to settle, and you're going to be part of it. Ms. Smythe, for instance, is going to be standing trial in front of a jury that y'all may end up on here for an offense that she feels she's not guilty of. She was justified in doing what she did. And the court system, and y'all being part of that court system, are going to have to settle it. Now, what do you think about that? The whole idea of a court system, does that make sense to you, the way we've set it up in this country, to have courts to settle these kinds of issues, these disagreements?
Yes.
Okay. And in a situation like this, where we have the state of Texas has come in and said, well, we think Mrs. Smythe has done something wrong. She's charged with disobeying the court. And she says, well, no, I didn't really, and if I did, I'm justified in doing it. Do you think that kind of argument should end up in the court system and be decided in the kind of procedures that we have in our courts?
Yes, it could be.
Why does that make sense to you? I mean, why is this court system, why is it a good thing to do?
Because it gives both sides an opportunity to speak and present their viewpoint, their perspective, and also to a group of people who are supposedly their peers.
What do you think about that? Do you agree with that? Yes, ma'am.
Yeah.
Do you think the courts are perfect in their operation?
You know, I saw on TV that there's been some cases reversed by DNA evidence.
What do you think about that? How do you feel about it?
I mean, I don't understand why we didn't get it right in the first place.
You, sir, why do you think that maybe the courts aren't perfect?
You're asking me?
Yes, sir.
Well, the courts aren't perfect because nothing's perfect. And the courts can't be perfect. They try to do as best they can, but I think ultimately mistakes will be made in the courts just like everywhere. And bad lawyering could be a part of it. Jurors, I think sometimes they get it wrong. I've heard about cases where judges have fallen asleep during the trials. Maybe that has something to do with it, but a lot of factors.
What do you think about that? Do you think courts are perfect?
No, anytime that people are involved, you're not going to have absolute perfection, but I think the jury is a pretty good check on the government.
Okay. What if it's not a jury's involved, just a judge making the decision? You think judges tend to be more perfect than jurors might be in making decisions like that?
I don't know if I agree with that or not. I think it would depend on the judge.
What do you think about that? What do you think about judges? I think they're more reliable or better decision makers than jurors would be?
Depends on the jury.
What do you think? Juries more reliable, judges more reliable? What do you think?
I think the jury's get it right because it's 12 people.
12 is better than one? Kind of collective wisdom approach. What do you think about that? Do you have an opinion on that?
That sounds right. That 12 people probably are more likely not to get it wrong at least.
What should happen? Let's say that it does happen, that we end up with a wrong result, or somebody who's involved in the process believes it's a wrong result. What should happen in that situation? Say you were a participant in a trial, and the court gives its ruling, and you just think the court's wrong.
Well, I want to have somebody that I can go take my complaint to.
Okay. Who might that be?
I would assume it would be another court.
In a higher court, some kind of appellate court or something. What do you think? What would you do, or how would you feel if you thought the court's decision was wrong?
Well, I guess if it was serious enough, I might, if I thought I absolutely had to, couldn't do what they said, I might not do what they said, or try to find somebody who would stop it.
Well, in general, do you think that people ought to follow the court's rulings even if they don't agree with them, even if they think they're wrong?
I guess
Well, let's take an example. Let's say an insurance company got sued for arising out of a car wreck. And the judge and jury came back and said, all right, you've got to pay $10,000 damage to the person who's injured in the car wreck. And the insurance company just said, well, we don't want you. Should they have to?
Well, there should be a penalty.
Why?
Because that's breaking the law.
What would happen? What would happen if, in that situation, the insurance company just said, we don't want to pay the money? And didn't pay the money? And nobody did anything about it? What would be the result of that? Yes, ma'am.
Well, then I would prompt other people to break the law and do the same thing. Nothing happens to them.
Okay. So generally, you think it's a good idea that people should follow court orders, whether they, even if they think it might not be a completely right court order? What do you think about that? Generally. Do you think there's ever a situation, or can you think of a situation, where a person might be justified in not following a court order? What kind of situation would that be?
Person comes to mind is contempt situation.
Okay. What is contempt?
Well, lawyer, that's the person that comes to mind. Lawyer doing something they think is right. Or the court has ordered them to do something and they're, for some reason, based on an obligation to their client, they're able to without violating constitutional standards.
What do you think, sir? Do you agree with your idea that there are some circumstances in which a person might be justified in not following the court order?
Yes.
Do you think that has to be a special circumstance or just pretty normal?
It would have to be special for the court order in general would have force.
Well, how can we figure out which situations in which a person would be justified in disobeying a court order as opposed to a more general situation in which people really should follow the court order? And what would be kind of general considerations we want to come up with that would set aside that special group of cases where a person would be justified in not following the court order?
And certainly, for example, if following a court order would lead to some kind of physical harm to someone, that would be a case where disobeying the court would be justified.
Okay, so the court order, the person feels like the judge has ruled wrong in this case, and as a result of the judge's wrong ruling, somebody's going to get seriously hurt. And what do you think about that? Would that be a situation, ma'am, like that you would think a person might be justified in not obeying the court order?
Yeah, I think it might be justified.
Okay. Do you agree with that? What do you think?
Me? Yeah, I agree.
Why would a person be justified in that situation? When if we're just talking about maybe just a few dollars of money, you're not justified in disobeying the court, but you are if someone can get hurt as a result.
But you are justified if someone can get hurt?
Yeah, you're justified in disobeying the court order if you think that by following the court order, somebody's going to get seriously injured.
I think because it's something that the law misses, it's a circumstance that doesn't cover under the law.
You seem a little puzzled by that. What do you think, sir?
I just can't imagine a judge ever, giving out some sort of an order that requires someone else to be injured. Doesn't make any sense.
Okay. Let me give you a hypothetical. That's a very good question because it is kind of hard to think of that. We trust our courts as a rule in this country. But let me give you a hypothetical. I just saw this about 5 minutes ago. Turns out a school is built over a pipeline that has traditionally just carried harmless substances, water basically. Just recently, it was turned out that a gasoline company has bought that pipeline and wants to transport gasoline through the pipeline. The pipeline is old, and there's some dispute about whether it's even safe to carry it under any circumstances, but particularly the area that's under the school is particularly fragile and weak and subject to leakage and possibly explosion. The judge hears the case, but it turns out that there's some dispute. The judge rules that, well, we're going to go ahead and let this happen. And the judge is going to let the gasoline go through the pipeline that afternoon, start going through it when the school is in session. And the person who's in charge of all this has been ordered to turn the valve to let the gasoline go through the pipeline, even though he has testified in court that his professional opinion as an engineer, that if he does that, the gasoline will get in there, the pressure will rush through the pipeline, it will explode, kill all the children in the school. Now, judge orders him to go turn the valve to send the gasoline rushing through the pipeline. Would that person, under those circumstances, in your opinion, be justified in disobeying that court order?
Yeah, I guess, it's a little troubling that he's using his judgment instead of the judgment of the court. But I guess if he feels strongly about it, that's his belief, they should follow that.
Yes, sir. What do you think about that?
I was in the military, and we got trained that if we follow orders, but if you get an order that's an illegal order, then you're under a duty to not do it. And I think the guy that you're talking about in that hypothetical is like that. If he refused to do that, I mean, that's a crime of conscience at that point. I mean, he might have to go to jail, but he's still in the right for doing what he believed was right.
But what if he does refuse to do it? Should he go to jail?
Well, I don't think he should, but, we talked about how it's not a perfect system. I don't think everything gets taken into account when people make decisions in court. So, if stuff didn't get taken, if it didn't get taken into account, the court's still going to rule one way or the other. So I don't think he should, but I have to.
Do you think he ought to go to jail in that situation?
I think he'll probably have to go to jail. I don't think he ought to go to jail, and he might be able to get out of jail.
Well, if you were on the jury, and the decision were yours in that circumstance, would you go to jail?
No.
And why not?
Because I believe he would be in the right, and he did something that he had to do to save people's lives. The court system had imperfect information somehow.
Fellow back there in the deep shirt, do you agree with that?
This is more red than pink.
He just told us a whole lot more information than you. Okay, let's stop it there so we can talk a little while. Now, the fact situation that I'm wondering on, and y'all don't know this yet, do you?
We sure took it up when he told us.
It's a custody case.
Can y'all predict what's going on here?
Yeah.
Who am I defending? Okay, what's going on? Why did she file that report?
Drunkards gonna pick her up and stuff like that.
Actually, the fact situation in this case is that the guy has been convicted of sexual abuse of a child before. After a disputed custody hearing, he's been given unsupervised visitation with a 4-year-old daughter, who, after the hearing, the mother was very unhappy, and later, shortly after the hearing, the child makes it out in front of the mother. It's not quite clear, but the child is unhappy about something the father has done for her. The mother has taken the child, hid the child, and will not return the child to the court until she gets a guarantee that the father will not have any unsupervised contact with the child. And that's a violation of court order. It's a community trial. Now, that's what I was wiring towards, and you can see what I was trying to do is to get people thinking about and talking about subject areas here. And this is stuff that people really don't sit around a dinner table and talk about that much. It's, we watch all these lawyer shows, but the truth of the matter is, a lot of cases that are tried in juries involve areas of thinking that people just haven't thought about much. So part of your role in doing this is just getting these ideas out and shaping questions and follow-up questions that will get people to talking about how they really feel about this stuff. What's their gut feeling? Talking at people is not going to get you anywhere. That's not what voir dire is. You're not going to change their fundamental beliefs about anything. Not going to convince them to do anything. When you get more sophisticated, get further into this and are more sophisticated with it, you will find that while the law says you cannot get a jury to contract, where you promise me you'll do this or you promise me you'll do that if the facts are such and such. He can't do that. But what you can really do is you can get jurors to start kind of contracting and shaping group attitudes about something that they didn't have before this whole process started. And you can't do that while they already have the predetermined attitude. You're not going to change that. But what you can do by skillfully shaping the discussion of your questions and your budgets in areas where they don't have any preformed opinions, you can get them to start thinking about it in such a way that as a group consensus, they will come together and form a kind of a contract among themselves. In this case, if I had another 30, 45 minutes, and if I'd had more time to plan this, I would be trying to get y'all to contract with the idea as you expressed it. That yeah, there are just certain situations in which a person is justified to disobey a court order, even though technically that's against the law, that there's a higher moral order at stake here, and a safety of someone is at stake here. And in that special circumstance, we all agree that we would not find a person guilty under the law. Even though the law says they must be found guilty technically, we will not do that. And that's what I would be working towards, getting y'all talking about that and shaping into that role. Does that make sense to you? Yeah.
Would you, in that situation, also get like factual questions, like if anybody had ever been involved in a podcast and dispute, et cetera? Or would you just... Yeah,
you probably would. The way you do all this is, and I don't think Bill had enough time to go into it, is you sit down and you try to figure out what are the driving emotional issues in your lawsuit. Whatever it is, I don't care if it's a car wreck, a contract dispute, a murder case, an intellectual property dispute. I don't care what it is, there's going to be an emotional component to that. Something that's going to drive the finder of fact, whether it's a judge or a jury. In this case, we're talking about juries. You find out what is driving them, and then you sit down and say, how can I formulate a set of open-ended questions that I can use to get people to talk about the emotional issues that drive their decision in this case. In a DWI case, those kind of emotional issues are going to be, well, how do you feel about drinking and driving in general? Just in general. There are some people who are very emotionally upset by the idea of anybody having anything to drink with alcoholic beverage and driving a car. Other people say, hey, that's fine as long as you don't lose control. That's all the time, no problem. You got to get into that issue, and then you got to get into this issue of how do you determine whether a person's intoxicated, how much it takes to get intoxicated, and the emotional issue of how much do you trust an officer's opinion testimony. And you try to think out what are the emotional issues driving this case, and then you shape open-ended questions, and not just one, but you want to have a series so that you can bounce it around from person to person. Mechanically, what you do is just like what law professors do in the Socratic method of teaching law school. Y'all be familiar with this. They give you a hypothetical, but they tweak it just a little bit, bounce it across the room to another student, tweak it a little bit more. It's the same kind of deal, and you just bounce it around. Think about having one of those big beach balls. You've seen big flavor ones, and you go to a sports event sometime, and that's bouncing around the stadium. Somebody brings one of those. You ever seen that? Think about it. That's what you're doing in voir dire. You're taking the emotional issue, you're bouncing it from one juror to another. To do that successfully mechanically, you start out with one basic question with whoever you start with, and then you can move it once, maybe twice, without tweaking it, without changing it just a little bit. But then you've got to change it a little bit, because otherwise it's not going to work anymore. It's too flat. So you add a little twist to it It keeps the same general idea going, but gives it a slightly different twist. And then you bounce it 2 or 3 more times, and then you give it a slightly another twist, and you bounce it 3 or 4 more times. As defense attorneys, you have the advantage that the other side has done their job right, like I said earlier, because you know who the talkers are. And so what you do is you always start the issue with a talker, someone who tends to be more garrulous than somebody who just sits there and very quiet. The other thing you want to do is watch everybody. Do not be taking notes. You have somebody else sitting over here taking notes. What you're doing is you're watching everybody and you're listening. When I say watching, I mean you're watching their body language. I'll be talking to this person over here, and they'll be saying something out of the corner of my eye. I look over here, he's going, she's so bitch. He's doing one of these deals. Well, what do you do? You go, after you finish up, well, do you agree or disagree with that, sir? He's going to jump up and say, well, I disagree, and here's why. And that's what you want to hear. You're not afraid that he disagrees. Even if she's saying all the right things, you love what she's saying. This is your IQ is yours. He's over here shaking his head. You got to find out what's going on over here. And you say, well, what's going on? Because he's going to be talking, he's going to give the opposing point of view. Don't be afraid to get it out. And you're going to see somebody else sitting around who's going to be over here, and now there's another one of you jerks sitting over here. You know, got a clean shirt back there. And that's going into the computer. And all this stuff. Where are these people coming out of this? And then you start with them, and you will be absolutely astonished how you can take 50 people that you've never seen before, and really on a felony case, your strike zone is 32, so you're really voir diring a matter of about 38, because you get about a half a dozen strikes from policy. You're voir diring about 38 people in reality. You will be amazed at how much you will know about these people, and yet you never stop. I mean, you just keep going asking these questions, because even when you think that you know this juror, that you got to ask them all the issues. I remember we were trying a date rape case a few years back, and it was a tricky case. My client had given a fairly extensive confession, which made it difficult for us. And we had a defensive theory that actually turned out working. We got not guilty of it, but there was one juror over here, and she was seated right where you are. And the first 4 sets, I had 5 questions that I was hitting. The first 4, she was right on target. I mean, she was ideal juror. She did everything perfectly. And I just wasn't going to touch her again, and she just kind of forced herself into the 5th question. We're just getting ready to wind up. And she opened her mouth, and it was like a kid in The Exorcist, you know, the British song, head spinning around. I mean, she opened up and let out some stuff, and we did, I made a jump when she did that. I was all set to take her, and she would have been a disaster for our defensive theory. You just can't predict how these people are very complicated things and they're not consistent. So you have to make sure you really get some feedback from every juror on every issue. The real lesson you got to learn here is people, human beings, are not fungible objects. Boxes of cereal are fungible items. Little toy dolls, one after the other, are fungible items. Human beings are not. When I first started practicing law, I was taught as a prosecutor at a law school. I went to these advanced prosecution schools and they taught us the most ridiculous bullshit you've ever heard in your life. For instance, as a prosecutor, you never take people on your jury whose professions start with a P. Oh, well, that's a good one. Plumbers, painters, preachers, prostitutes. If it's a profession that starts with P, you don't talk to them. You just scratch them off and you strike them off. I practice law that way. I mean, it's horrible. We really did that. That's how we were taught. That's how primitive the art of voir dire was back then. That was the official teaching. You know, you just categorize people. Well, you don't take black people on your jury because all black people have this attitude about this issue. That's just nonsense. Or all women think this way about this. Or everybody who lives in Northwest Hills thinks this. Or everybody drives a Buick has this attitude about something. Everybody with red hair thinks it. Pink shirts, they think that. It's just not. People are so much more complicated than that. Law students are all the same, right? Every one of y'all thinks exactly the same about every issue because you're a law student, right? Law. And you got to keep that in mind. You got to avoid categorizing and boxing people in that way. And yet you see lawyers get up and do that all the time. They do a kind of voir dire bill. You got this did for you, get up and talk with the jury for 45 minutes. They'll ask a lot of things about it. If you ever hear a lawyer saying, well, I take it by your silence. You can take anything you want. It doesn't mean anything. And then they say, well, this guy's a preacher, he'll be good for us because, and you know, Catholic priests are great because they're so forgiving. Well, I would certainly want Catholic priests on my jury for that reason. And a plumber, you know, plumbers and painters drink a lot, so I want them on my jury. You just go down and watch it. About half of your voir dires are going to be of that quality. But every once in a while, you'll see a voir dire done right. I remember we were trying aggravated sexual assault case trial a few years back. And this one Frank Bryan did that terrible opening voir dire. He really put me to sleep, let me tell you. And it was kind of tough because we didn't have much sense of who they were when I started. And I brought them out for 45 minutes. And when I sat out, I told my co-counsel, I said, if they leave number 12 on the jury, he'll be the foreman, and he'll take somebody who will not guilty, and he'll bring some people with him. And they went back, we did our strikes. The state did not strike number 12. When the jurors came back at the end of the trial, it was hung 6-6. He was the foreman. He voted not guilty and brought 5 others with him. And that's not because I'm especially good at this or I'm especially bright. I'm not. There are a lot of lawyers who do better than I do, but that's how easy this stuff really is if you do it the right way. These people will talk to you and tell you how they feel, and you can really get that sense. You have to read them as human beings. Now, the reason lawyers don't do it right, I'm convinced, is because we as a group tend to be control freaks. We want to control what goes on in the courtroom as much as possible. We train and we work and we teach you all how to do it. When you're putting on the evidence, we want you to be in complete control in that courtroom, right? And we do want you to be in control. But there's one time you cannot be in control, and that's when you're doing voir dire. You have to let it go and let the jurors just go. You just got to let it. Just bounce it around and let whatever comes out, come out. And then you'll learn who you want on the jury and who you don't want. Yeah.
What about the problem where you've got a juror that you're dead set on you don't want to open them up to the prosecution?
How do you know they want to be yours if you haven't talked to them?
Well, I don't know. I like she said the lady had 4 questions right and the last one was wrong, so you were glad to get rid of her. But I think that's kind of more of an exception rather than the rule. And so I'm just saying if you've got a situation where they're answering the right questions, and so you're not going to pursue them any further than you could.
Well, I mean, there are times when you have a sense that there's a juror who's really going to be the kind of juror you want. But I mean, the one thing everybody seems to be afraid of it is they're saying, well, if I voir dire do a really good job, I need all the jurors giving all this information, then the other side is going to find out about it too because they're listening, right? Yeah. There's just nothing we can do about that. I mean, if I can put them in a silent room where they couldn't hear, I would. But that's the downside. I mean, when you do a great voir dire and you really get all this stuff out, no matter how inept the other person was on their voir dire, they get the same benefit from your voir dire as you do. And you just got to live with that.
Yeah. I'd like to add a 4th element to Bill's statements before we came in here as to the purpose of voir dire. And I think a very important purpose is to get the jury to like you. And I think if you just use the example of you and Bill up there this morning, or this evening, how many of you like Bill? You know, how many of you like Dave? Of course, you always like Dave.
I'm in the room, I'm instructed.
But if you want to build credibility with the jury, the first and best place to do it is through voir dire.
Yeah. Your whole conduct in the courtroom has to be aimed towards credibility and legality of the jury. And voir dire is no exception.
Were you purposely not telling us what this case was about? Because we obviously didn't get it from Bill.
We really don't in criminal cases tell much about what the case is about. And I don't like to do that because even if I were allowed to, and a lot of judges don't let you tell anything just based on the charges, they will not let you tell the jury any facts. You go to civil court, they try the case on voir dire. In criminal court, we don't do that. And I don't know whether that's about customer statute, but I've never cleared the reason for that. But the truth is, they know what the charge is, but none of the facts. But even if I were allowed to give you all the facts, I wouldn't want to do it because I think it's getting in the way of me trying to find out what your feelings are about these things because the jurors would start focusing on facts and shaping their answers to fit the facts would only be incomplete at that point.
The reason I ask is because, despite Ken's question on the go, I was frustrated with both attorneys because I'm sitting here, and to use your analogy, you're bouncing the beach ball around and I'm sitting in the audience, but I don't even know I'm at a baseball game and I don't even know who's playing.
Right.
Because I don't know what the hell's going on.
Yeah.
I mean, he got up and read this complicated charge that, even though we have experience with legal language, it was difficult to follow. And I don't even know why I'm here yet. Nobody's even told me that. I just figured it out through your questions, but a lot of jurors aren't going to do that.
Right. It's just, we just don't, in criminal courts, I don't know what Ken just bailed out. Can I ask Ken? Boston, I don't know what the basis of why we try those cases that way in criminal court, but the facts never come out. Only the charge does.
You can't even introduce your clients, and my client's been charged with.
Yeah, you do that.
I mean, put it in like plain language, like, my client took her daughter.
No. What I would do in a real case is I would introduce my client, have her stand up, and I would get a little bit of information about her on the pretext, asking y'all, one of the questions I always ask is if you know her, have any contact with her. And I justify Richard Segura's evil trick of, telling all about your client. So, I'll tell you a story about this, which kind of contradicts one of the things Bill was talking about. The guys that I have to know, give y'all enough information to know whether you have worked with her at the same company or live in the same neighborhood, that sort of thing. Interesting story. Bill was talking about the RAND study that jurors do not remember anything as lawyers tell them, which I think is generally true. But I think that it's a little more sophisticated than that. What really happens is jurors hear a lot of stuff, they just don't remember where it came from. Richard's prostitution case, not his client's prostitution case. But roughly a guy who's some kind of manual laborer who's charged in prostitution state. And Richard, introducing his client to the jury, says, my client is Joe Smith, and he works, whatever job it is, a janitor. A janitor, all right. And anybody knows he works at janitor at ABC company. Now nobody knows it. Well, later, the jury finds him guilty, they go out on punishment, they come back, and they assess him a $200 fine. No jail time, no probation, just a $200 fine. And the guy did not testify. And they all went back to talk to jurors after the trials, which he always did. I said, well, why did you select the $200 fine? They said, well, the testimony was that he was a janitor, and we figured we'd just find a week's wages, and we figured that was a week's wages of a janitor. Everybody's going, what testimony are you talking about? Richard said, they heard it somewhere. It hung in there. They didn't know where it came from.
Let me tell you the flip side of that.
Yeah.
I tried a DWI case a couple of years back. A really nice kid. He told me he was in the choir at the First Yada Yada Church, and that's what I introduced him at in Voir. When Ireland said, well, I know that church. I've never seen it. Just make sure he's in the choir before he stopped. But he was really in the choir. It can burn you too.
Did you strike that down?
I can't
But I think what happens is they don't remember things that lawyers do. But one of the things lawyers, I think, they try to do is they become so convinced that they can persuade people that they think they can change fundamental attitudes about people. I mean, and that's kind of akin to them saying, well, I'm going to take all the Jews on the jury, I'm going to turn them to Christians, and I'm going to take all the Christians and turn them to Muslims, and I'm going to take all the Muslims and turn them to Mormons. I can do that because I'm such a skillful, persuasive person. In 30 minutes, I can do this to all these people. And it's just nonsense. You're not going to change anybody's attitudes. All you're trying to do is find out what those attitudes are. How do those attitudes fit into your ideal juror profile? And then you'll know which ones to strike and which ones to leave on the jury. Okay. I think we're about out of time. I'm sorry I didn't keep going. We'll see you next week.